May I make a submission, my lord? Supply of pharmaceutical items.
Who is he?
उधर जाओ, उधर. Sir,
You need his assistance.
no, not assistant.
All right.
My lord, supply of medical equipment.
Mm.
Auto driver comes and dispatch and goes away.
Mm.
Now the auto driver, I have examined him. He was cross-examined. After 10 adjournment, they cross-examined him.
Mm.
During the course of cross-examination, the trial court directed him to complete the cross-examination on the same day.
Mm.
He did not do so. Thereby, the court has closed the cross-examination. And 10 adjournment
In
was taken.
2018.
2016, my lord.
Mm.
2016.
Mm.
And application came to be filed by the accused advocate, for which application came to be dismissed. Subsequently, they filed a revision petition instead of filing a petition. That petition they prosecuted for 8 years, my lord, just for the sake of collecting 3 lakhs medicine money. This is the attitude, my lord.
Let him be present and next date of hearing. I will proceed with the
I
cross-examination.
will not permit. Yes. 311 application I allow like this, but this I will not.
My lord, the appellate court, my lord, did not
No
decide on the
problem,
merits
sir.
of the application, my
Who
lord.
is PW2?
He is a person who has, says that he has supplied the materials to me.
Where do you find him now?
My lord, he
10
is,
ವರ್ಷ ಆಗಿದೆ. Where do you find him now?
my lord, last occasion he was present. He was regularly present before the court, my lord.
Last occasion ಯಾವಾಗ?
2000.
16 ಅಲ್ಲಿ. ಆ ಲಾಸ್ಟ್ occasion ಕೇಳಿ.
ಒಂದು ಅವಕಾಶ. On cross.
ಯಾವ ಅವಕಾಶ? No, we will not direct, we will not permit an impossibility in terms of the order. Yes.
My lord, when I preferred a revision petition before the appellate court.
Why did you prefer a revision petition?
Revision petition was pending consideration
What to
before the appellate court.
What to do, sir?
And it did not decide on the merits, it decided on the technicality, saying that you cannot maintain a
What
petition.
to do? Time flies.
My lord says here.
And he has also flown somewhere. Auto driver ನೆಲ್ಲಿ ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ ಈಗ? We will not permit something that cannot be achieved.
My lord,
And you want to achieve something else, so this will not permit.
may I make one submission.
Yes.
On cost, I request my lord, let him take it. I will take a chance. If it does not come also, we will proceed with the case.
No,
Let there be a direction to dispose of the complaint
Not
within
to
1
the-
month.
Not to the satisfaction of your client that this court will pass orders.
My lords, it's not a, that for, to meet the ends of justice, my
ಯಾವ ಎಂಡ್ಸು ಎಂಡ್ ಆಗೋಗಿದೆ ಎಲ್ಲ ಇಲ್ಲಿ ಯಾವ್ದಿಲ್ಲ. ಜಸ್ಟಿಸ್ ಶುಡ್ ಬಿ ಡೆಲಿವರ್ಡ್ ಅಲ್ಲ ಅಷ್ಟೇ.
ಒಂದು ಅವಕಾಶ ಅಷ್ಟೇ.
ಯಾವ ಅವಕಾಶ?
In this, let him be
ಆಟೋ
present.
ಡ್ರೈವರ್
on
ಎಲ್ಲಿ
that
ಕರ್ಕೊಂಡ್
day.
ಬರ್ತಾರೆ ಸರ್ ಅವರು?
One
1 minute. ಒಂದು ಅವಕಾಶ ಅಂದ್ರೆ ಆಟೋ ಡ್ರೈವರ್ ಎಲ್ಲಿ ಕರ್ಕೊಂಡ್ ಬರ್ತಾರೆ? ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್
worker.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ಸ್ ವಾಟ್ ವರ್ಕರ್? 2014 ಅಲ್ಲಿ CC of 2016, incident of 2015. Permanent auto driver ಇವರಿಗೆ?
ಅಲ್ಲ, I am not aware of it.
You are not aware of it. He is not aware of where is he?
Let him make a statement, but he is not aware, then I will close before this court. My lord,
ಯಾಕ್?
my lord, 1 second, 1 second. Let that be the imposition of cost. Let the PW2 be summoned, my lord.
ಒಟ್ಟಲ್ಲಿ ಅಲೋ ಮಾಡ್ಬೇಕು petition.
Lord, fair to me.
ಏನ್ fair? Nothing. This is unfair. 138 proceedings ಅಲ್ಲಿ ಏನ್ sir?
ಅಲ್ಲ, ನಾನು ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೋಗಿದ್ದಾಗ they could have
ಯಾಕ್
rejected
ಹೋದ್ರಿ?
it at the first
Why
instance.
did you go?
My lord, court could have rejected it.
District court has kept it for 6 years.
There was a stay order.
Or what to do? Stay order not to terminate that auto driver.
Not to
ಮತ್ತೆ
terminate.
he has
but
gone
not to
somewhere.
further proceed with the case.
This will only lead to dragging of the proceedings and nothing else. Anything else?
One opportunity on
No, sir,
cost.
not in this case. Where do you get the 10 adjournments sought for PW2?
The admission made by the petition copy.
Petition copy la.
Our petition.
Even PW2 did not present for 5 hearing, my lord.
ಅವಾಗ್ಲೇ ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಎಲ್ಲೂ.
ಇಲ್ಲ, ಆಮೇಲೆ ಬರ್ತಾರೆ ಅವರು.
ಬಂದ್-
ಆಮೇಲೆ ಬರ್ತಾನೆ. ಅವತ್ತಿನ ದಿವಸ ನಮ್ಮ ವಕೀಲರು ಕ್ರಾಸ್ ಮಾಡ್ಲಿಲ್ಲ, ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರು.
The petitioner is before this court calling in question an order passed by the learned magistrate and the court of session respectively, whereby the application seeking recall of PW2 for further cross-examination comes to be turned down. The petitioner is the accused, this respondent, the complainant. The two are said to have had a transaction. The transaction leads to, a transaction is with regard to supply of surgical items and medicine in terms of what was ordered by the petitioner on 18/12/2015. The 2015. In furtherance of the transaction, it transpires that the accused has tendered certain checks. The checks were dishonored. Dishonoring of the checks leads the complainant to the concerned court invoking section 200 of the CRPC. The concerned court registers CC. The petitioner himself avers in the petition that on 10 occasions, the matter was posted for the purpose of cross-examination of PW2, and he was partly cross-examined on 2 or 3 occasions. It is then an application is filed seeking recall of PW2 for the purpose of further cross-examination. This comes to be rejected. The rejection of which is called in question before the court of session. The court of session grants an interim order of stay of further proceedings before the concerned court. Interim order, the order sheet would indicate that the interim order was initially granted but not extended from time to time. Notwithstanding the non-extension of the interim order by the court of session, the learned magistrate does not proceed with the matter. Finally, the court of session dismisses the application against which the petitioner is before this court in the subject petition. The learned counsel for the petitioner submits that if one opportunity is granted, he would conclude the cross-examination of PW2 on the same date and would not drag the proceedings any further. Counsel for the respondent submits that PW2 is a driver of an auto rickshaw who had supplied the goods in the year 2016. His whereabouts are not known today, even to the complainant. Therefore, even if this court would direct production of PW2 for further cross-examination, it is an impossibility to trace him. He would therefore seek dismissal of the petition on account of the fact that the petitioner has lost all opportunity to cross-examine PW2 at the relevant point in time. As the purport of section 311 is towards the discovery of truth in a criminal trial, the present proceeding is a quasi-criminal trial, and the petitioner has lost all the opportunity, not one but on 10 occasions, to completely cross-examine PW2. And PW2, being the driver of an auto rickshaw which had only supplied the material, would not be in the same position 9 years after the transaction. Even otherwise, the supply of material need not be elicited from a driver of an auto rickshaw. If the documents are available on record, that would suffice for demand and supply check being issued towards the demand and supply. For PW2 would be directed to be brought for cross-examination, it would be directing an impossibility, as the tracing of PW2 would pose a great difficulty and delay the trial. In that light, finding no warrant to interfere with the orders passed by the concerned courts, the petition stands rejected.